Hello and good afternoon. My name is Lexi, an automated AI voice assistant. Before we move on, it is my task to explain the application of AI in this presentation. This presentation is made wholly using AI. Firstly, an AI machine known as facial recognition was used to capture the facial features and expressions of the presenters, while minor movements of the presenters were based on a tool called pose estimation. Secondly, data for voice recognition was captured to simulate the same tone and pitch of the presenters. Using AI, a video presentation of each presenter was created based on the raw data collected. As a result, the presenter will only need to type the script into the system.
Assalamualaikum, I am Imran Ali and I shall begin my presentation by stating the problem statements. Artificial intelligence or AI was introduced in criminal sentencing by the Court of Sabah and Sarawak in early 2020. Although there are benefits of using AI in criminal sentencing, there are however some concerns pertaining to the aspects of procedural fairness and substantive fairness of using it. Some of the concerns are as follows. First, is the outstanding issue of transparency of AI in regards to its reasoning in imposing criminal sentences. AI is a machine that could provide a recommendation of a sentence that is applicable to the offender. However, the reasoning of recommending such a sentence is unexplainable. This is due to the complexity of the models adopted by AI that uses large datasets to analyze specific factors or combination of factors. As a result, it will be difficult for the AI machine to identify a specific and precise reason for its decision. Second, AI is susceptible to biases. This is as it may occur during the process of training AI applications when the data used is biased as a result of the developer's values and principles that are biased in nature. Therefore, bias in AI will reinstate the current discrimination and only prejudices towards the affected groups of society. Lastly, the use of AI sentencing takes away the task of administering sentences from the judges. Consequently, it creates a predicament where the discretion of the judges is taken away from them. The AI system may be consistent in producing sentences, however, it does lack the necessary critical skills to ensure justice is not only administered but seen to be administered. Therefore, these problems beg some questions for us researchers to answer. First question is, how does AI work and produce a decision based on the parameters in criminal sentencing in Malaysia? This question seeks to understand the function of AI in criminal sentencing. The second question is, what are the weaknesses of the existing application of AI sentencing in Malaysia for criminal offenders? We have discussed about the several concerns of using AI in criminal sentencing. Hence, why do AIs produces these concerns? And what are actually the weaknesses? The third question is, how does China operate smart courts in relation to AI sentencing and decision making? This question specifically raises our curiosity over the smart courts operation in China. And lastly, what are the recommendations for improving the existing application of AI in criminal sentencing in Malaysia based on smart courts in China? To answer these questions, there are several research objectives that are in line with our research questions. The first objective is for us to determine the process of AI in making a decision based on the parameters in criminal sentencing in Malaysia. Second objective for us is to examine the weaknesses of the existing application of AI sentencing in Malaysia for criminal offenders. And third objective is for us to analyze the operations of smart courts in China relating to AI sentencing and decision making. And naturally, once we have done that, our objective is to provide recommendation to improve the existing application of AI in criminal sentencing in Malaysia based on the smart courts in China. Hence, those are our research questions and also research objectives. That's all for me. Thank you.
Moving on to the scope of the study. So this study is on AI sentencing in criminal cases in Malaysia. This study is particularly restricted to the field of criminal law. Why? This is because in Malaysia, only criminal cases involve the usage of AI in sentencing. With respect to criminal sentencing, the focus will be on the judiciary of Sabah and Sarawak, which have already adopted the use of AI, and also Science, the private company behind this. The implementation of AI in criminal sentencing is done by 3 courts as of now, namely in Sabah, Sarawak and Kuala Lumpur. However, the implementation in Kuala Lumpur courts will be excluded from the study, as the implementation is relatively recent and it is based on the implementation in the courts of Sabah and Sarawak. Despite the restriction, the scope is extensive enough and adequate to achieve the objective of the study in assessing the current AI sentencing framework and subsequently to propose a viable alternative to enhance the existing framework governing the implementation of AI in Malaysia. The discussion revolves around the procedure of implementing AI in the act of sentencing, which is largely guided by algorithm. The legislation referred to in relation to AI criminal sentencing is restricted to the Dangerous Drug Act 1952 Act 234, as AI criminal sentencing in Malaysia is only subjected to the offence under the Act. And for the purpose of a comparative law study, the implementation of AI in China Smart Court will be analysed. The main focus is on AI sentencing and decision making. Moving on to the limitation of the study. In relation to the limitation of the study, the main restriction faced is the limited journal regarding the implementation of AI sentencing in Malaysia. The field of AI sentencing in Malaysia is still relatively new, and most literature discuss the use of AI in criminal sentencing based on the generally accepted connotation, which is AI sentencing should not be implemented. Furthermore, there is an issue of language barrier in journals. This study compared the jurisdiction of Malaysia and China, and most literature found are written in official language of China, which is Mandarin. Therefore, much literature written in Mandarin Chinese could not be used, and also the authors. As a result, statistical data from the Chinese government could not be accessed in the study. Nevertheless, some journals are translated into English, or the Mandarin language journals are cited in English. Lastly, accessibility to updated secondary sources via local libraries comes with a cost, as online local libraries subscribe to a limited amount of literature, and many of the latest and also recently added journals must be paid to be accessed.
Good day to Dr. Ilyana and everyone. My name is Zubli Kuzari bin Zubli, and today I will be highlighting the gaps based on our literature review. There are 4 gaps that have been identified, which are generalization by local research, issue with framework, lack of recommendations, and no comparative study. Firstly, studies conducted locally had generalized the use of AI sentencing. Most literature compared AI sentencing in Malaysia to the American Correctional Offender Management Providing for Alternative Sanctions, or in short, COMPAS. COMPAS is an AI risk assessment that determines whether a person might re-offend or not, while AI sentencing is for criminal sentencing according to the procedural law and some other factors. Generalizing that all AI is the same is incorrect and resulting to biasness in saying that AI is not good. To bridge the gap, it is vital to compare AI sentencing in Malaysia to a similar system of AI sentencing or decision making, as treating like cases alike. Secondly, the issue with framework had not been fully discussed. Discussion revolves around technical part of AI by itself is incompetent. It is important to see the bigger picture and look from the legal aspect and framework of implementing AI sentencing. To close the gap, we will be highlighting the problem with AI based on government policy, applicable statute, and transparency of the judiciary itself. Thirdly, lack of recommendation in solving the issue with AI. Most studies focus on the issue of AI and not the solution. One solution by Nazura and Nazrul is to enact law and policy to regulate AI. By enacting law and policy is not sufficient. As such, the gap can be filled by the authors through giving solid and practical recommendations. And lastly, no comparative study had been conducted for AI sentencing in Malaysia as of today. China has produced great results in AI sentencing and decision making because of the government policy, transparency of the judiciary, and also cooperation with private sector. To close this gap, there is a need to compare between the implementation of AI sentencing and decision making in China and AI sentencing in Malaysia. With that, thank you very much.
Now, moving on to the research methodology, when firstly we would have to focus on the doctrinal legal research. According to Jane, it is a judicial reasoning or reasonable deduction studies of legal institutions and case law analysis. Not only that, it also includes classifying, organizing, and also systematizing of legal arguments. The secondary sources of law used for our study include textbooks, journal articles, theses, and newspaper articles. They can be found from online database resources such as Lexi's Legal Research for Academics, CLJ Law, and also Hein Online. We also took secondary sources of law from relevant institutions' website and also websites belonging to non-governmental organizations. Before we look into the method used for this study, we firstly have to define methodology. Hart defines methodology as the study of the accepted standards for scientific arguments. Now, the method chosen for this study is the comparative law method. Ebel defines the comparative law method as the act of comparing the law of one country to that of another. The comparative law method also provides a way to perform legal transplant, which is the process of adopting legal solutions from other countries to one's own legal system. Now, in any comparative law study, there must be a comparative jurisdiction. Therefore, in this particular study, we have selected China as the comparative jurisdiction. In specific, we would like to look into China's smart courts. Moving on to the criteria used in selecting China as our comparative jurisdiction. Firstly, China is a non-Western country which has successfully implemented AI sentencing in comparison to other Western countries, such as United States of America. Secondly, China has pushed for AI to be incorporated into and throughout every sector of the society, thus enlarging its role in assisting the judiciary rather than just providing sentencing recommendations. Thirdly, the implementation of AI in China stretches beyond cases in the criminal jurisdiction only, with it actually maintaining the same amount of efficiency by providing quick analysis and recommending judgment to judges in a very short time. The fourth yardstick used in selecting China as our comparative jurisdiction has to do with its high percentage of accuracy of the AI system used in China, which is used to analyze complicated work and simple cases. Now, of all these criteria used above, we believe that it provides a solid justification in selecting China as the comparative jurisdiction.
Assalamualaikum madam, my name is Hazrul Hakim and I will be the final presenter for my group. To continue our presentation, I will be presenting the significance that we have found from our legal research, a comparative study of AI sentencing in Malaysia and China's smart court. From our research and literature review, we were able to identify 5 significance as you can see from our slide. First of all, the outcome of the study will serve as a useful reference for the regulator or policymaker in establishing a more efficient application of AI in criminal sentencing. Secondly, the study will benefit individuals and society by ensuring adequate and equal protection through the establishment of AI in criminal sentencing. Next, the implementation of the recommendation will also significantly improve the judiciary system and reduce time for criminal trials, ensure consistent judgment, and prevent unnecessary biases due to the sharp and quick decision made by the implementation of AI. Furthermore, this study will also enrich the literature on the application of AI in Malaysia's criminal sentencing, particularly from the aspect of institutional framework, which has not been widely covered in the existing literature. And lastly, the implementation of AI sentencing in Malaysia will provide an accessible justice system to all citizens and ensure an effective and accountable judiciary institution at all levels, which also aligns with Malaysia's 16 social development goals. In conclusion, the use of AI in Malaysian criminal sentencing is undeniably important, as it brings a lot of benefit in terms of efficiency and consistency in the judiciary system. However, with the gap that exists in our AI implementation, continuing the use of AI without any improvement to the current system will only lead up to more confusion in assessing the AI decision and also will lead to discrimination and biases. Hence, through comparing the implementation between Malaysia and China's smart court, we will be able to solve the gap if the Malaysian judiciary is able to follow the AI system that is used in the smart court of China, as their system can ensure a more cohesive and sustainable judgment in criminal sentencing. With that being said, we have come to the end of our presentation. Thank you so much for listening and Assalamualaikum.